In part 1, we met the CAG briefly as one name in a longer list of constitutional bodies. Today we give it the depth it deserves because look at the PYQ record of Comptroller and Auditor General. UPSC asked in 2024, 2018 and 2016. So this is one of the most consistently tested institutions in GS2. And UPSC keeps asking same underlying question in different cloths. So let us begin with a simple scenario. Let's say Parliament sanctions 10,000 crore rupees for a rural health mission. The money is spent, the scheme is implemented. Then who checks whether that money was spent lawfully or not? And more importantly, whether it was spent well? That is the CAG's job. That is the Controller and Auditor General of India's job. And the word well is exactly where the controversy begins. Article 148 establishes the Office of Controller and Auditor General of India. And Article 149 defines its duties and powers, drawing on the Pre-Independence Government of India Act framework we studied in historical underpinnings in previous classes. So this is another example of continuity through borrowing rather than rejection. So CAG is Pre-Independence Government of India Act framework withdrawn from there. So this is the continuity through borrowing rather than rejection. And note one detail worth writing in any answer of your mains answer writing, that is Article 149 itself does not exhaustively list the duties. It authorizes Parliament to prescribe them by law, which Parliament did through the CAG's duties, powers and conditions of services Act 1971. So the office is constitutional, but the operational detail of its mandate is statutory. So a hybrid design UPSC quietly rewards you for noticing. That is why I am explicitly saying this thing. So the CAG audits the accounts of the union, the states, and any body substantially financed by government funds, and submits reports that go to the president or governor, who lay them before the legislature, where the public accounts committee takes over from onwards after laying the before the legislature. So now here is the PYQ's real question asked almost word to word in 2024. I am saying this. Is the CAG's duty merely to check the legality of expenditure or also its propriety? Is the CAG's duty merely check the legality of expenditure or also its propriety? So legality asks, was this money spent as sanctioned following the rules? But comes to propriety, asks a harder question. even if the rules were technically followed, was this expenditure wise, economical, and in the public interest? A government could spend money entirely within the rules and still spend it wastefully. Three luxury cars for one department, let's say example, a stadium that never hosts an event. So legality alone would give it a clean sheet. So propriety audit exists precisely to catch the gap. That is what in the 2024 question they asked. So this connects directly to the 2016 question. Does auditing government policy implementation amount to the CAG overstepping its jurisdiction? Does auditing government policy implementation amount to the CAG overstepping its jurisdiction? Here UPSC wants balanced reasoning, not a one side taken absolutely. The CAG is not meant to audit the wisdom of a policy. That is political and legislative questions, not an auditors. But it is absolutely meant to audit the efficiency and outcome of implementing the policy. Did the money achieve what it was meant to achieve? So, the line between was this policy a good idea and was this policy implemented efficiently is where the real analytical tension sits. And it is exactly this line, the 2G spectrum and coal block allocation, CAG reports tested in practice. In that cases, reports that quantified presumptive loss, a methodology that itself became controversial. So comes to the independence. The CAG is appointed by the president, holds office for 6 years or until the age of 65. And be precise here because aspirants routinely lose an easy mark on this. Is removed in the same manner as a Supreme Court judge by the president after an address by both houses of parliament supported by a special majority on grounds of proved misbehavior or incapacity. To not call this impeachment. Impeachment, strictly speaking, is the process reserved for the President of India under Article 61. So that is why I'm saying the correct phrase here is removal in the manner of a Supreme Court judge. Removal in the manner of Supreme Court judge. Further, the CAG cannot hold any further office under the government of India or any state after retirement. And the salary and service conditions cannot be varied to the CAG's disadvantage during the term. So these safeguards exist for the same reason judicial independence exists. An auditor who fears the government he audits cannot audit honestly. So one reform criticism worth carrying now, that is the thing. The constitution is silent on the appointment procedure itself. The executive effectively selects its own auditor, and the reform proposals have suggested a collegium style or committee based selection. The same structural fix we will see proposed for the CBI director, the election commissioners, and the Lokpal. This is regarding appointment gap for CAG. Comes to the answer writing part. Suppose UPSC asks simple question like this. The duty of CAG is not merely to ensure the legality of expenditure, but also its propriety. Comment. This is the question. What should be the high scoring answer? First and foremost, what you have to do is defines both terms precisely. Then explain why propriety audit is essential in a welfare state where efficiency of spending matters as much as legality. Then discusses landmark instances where CAG reports shaped public accountability debates, and then addresses the criticism of judicial style presumptive laws, figures entering public discourse without full context, and then concludes that propriety audit strengthens rather than exceeds the CAG's constitutional mandate, provided it stays within evaluating implementation rather than second guessing policy choice itself. So let us summarize. The CAG does not merely count rupees, it evaluates whether public money served in the public or not. That is the difference between an accountant and a constitutional guardian of the public purse. That is CAG. So this is regarding about CAG, Controller and Auditor General, Propriety Audit and Legality Audit, and 2016 question and 2024 question, etc. Then comes to the next constitutional body, that is Attorney General, the union's chief law officer, that is Attorney General. Now to a genuine gap we are closing today, that is the Attorney General appeared twice in PYQ record in 2025 and 2019. So you have to ask yourself once, the government of India is in effect the single largest litigant in the country. Every ministry, every policy, every law it passes can end up in court. Who represents the Union of India in the Supreme Court? And who advises the government on complex legal questions before they become disputes at all? Think once. That officer is the Attorney General under Article 76. The Attorney General is appointed by the President, must be qualified to be a Supreme Court judge, and is the highest law officer of the country. But notice something important here. The Attorney General is not a member of the Council of Ministers and is not part of the cabinet and is not a government employee in the ordinary sense. The office occupies a unique constitutional position, an independent legal advisor to the government, not a political accountable minister. Though appointed on the advice of the Council of Ministers and holding office at the President's pleasure. And here you have to note two structural gaps where UPSC interprets with questions. What are they? The Constitution fixes no term of office and no fixed remuneration for Attorney General. No fixed term, no fixed remuneration. Just holds office at the President's pleasure. Tenure rests entirely on the pleasure doctrine, and by convention, the AG resigns when the government changes, which tells you the office, through constitutionally independent in function, is politically aligned in practice. Why? By convention resigns when the government changes. That is why it is independent in function constitutionally, but politically aligned in practice. So, what does the AG actually do? Advises the government of India on legal matters referred by the president and performs legal duties assigned by the president and represents the government in the Supreme Court and in any high court where the government is a party. Appears in any cases of public importance when requested and has the right to speak and take part in the proceedings of both houses of parliament and any joint sitting and any parliamentary committee of which he is named a member, but without the right to vote. But without the right to vote, this is important. Without the right to vote, since he is not an elected member, so the AG is also enjoys the privileges and immunities of a member of parliament. Now the 2025 question PYQ pushes further responsibilities, rights, and limitations. What are the limitations? What are the limitations? The AG cannot advise or hold a brief against the government of India, cannot defend an accused in a criminal prosecution without government permission. Without government permission. Cannot accept directorships in companies without permission. These restrictions exist because the office carries privileged access to government legal strategy. The same logic of avoiding conflict of interest that runs through judicial independence and the CAG's post-retirement restrictions. Unlike the CAG, the AG is not debarred from private legal practice. The restrictions only fence off conflicts with the government's interest, which is itself a point of criticism. So comes to the contemporary relevance. What is the AG's contemporary relevance? The AG's opinion often becomes the deciding factor. The AG's opinion often becomes the deciding factor in whether the government pursues or drops a prosecution, appeals a judgment, or defends a contested law. So making the office quietly central to governance, even though it rarely makes headlines the way ministers do. So this is all about AG, Attorney General. Comes to the answer writing point. Suppose UPSC asks the 2025 question directly like this. The Attorney General of India plays a crucial role in guiding the legal framework of the union government and ensuring sound governance through legal counsel. Discuss. Discuss his responsibilities, rights, and limitations. This is the actual question. The Attorney General of India plays a crucial role in guiding the legal framework of the union government and ensuring sound governance through the legal counsel. Discuss his responsibilities, rights, and limitations. Comes to the answer structure. You have to first explain the constitutional basis under Article 76. Distinguishes the AG's advisory and litigation roles. Then discusses parliamentary participation rights. Then evaluates the restrictions designed to prevent a conflict of interest. And then closes by noting the AG's quiet but structurally important role in shaping how the union approaches litigation and legal policy. Never forget this distinction because it is where aspirants routinely lose marks. The Attorney General is not a politician and not quite a civil servant. A distinct constitutional category. The union's independent legal conscience bound to serve the government's legal interest while remaining answerable to constitutional propriety rather than political convenience. So you have to remember all the time the Attorney General is not a politician and not quite a civil servant, a distinct constitutional category, the union's independent legal conscience bound to serve the government's legal interest while remaining answerable to constitutional propriety rather than political convenience. It is all regarding about AG limitations and the exam frame is concerned. Then we are moving to central investigation agencies, that is the CBI and the federalism question. A scene that answers a 2021 PYQ almost directly. What is that? And belongs as a direct continuation of your federalism chapter. Because that is exactly what it is federalism tested through investigation law rather than legislative lists. Here is the puzzle. What is that puzzle? Police and public order are state subjects under the state list. We established that clearly in federalism. Separation of powers, union list, state list, and concurrent list. So, how does a central agency investigate crimes inside a state at all? Think once. The answer lies in one piece of legislation, that is the Delhi Special Police Establishment Act 1946. The CBI is not even a constitutional or dedicated statutory body in the way NHRC or Lokpal. It derives its authority from this pre-independence police establishment law that is extended to give it jurisdiction beyond Delhi. CBI runs on the Delhi Special Police Establishment Act 1946, neither constitutional nor a dedicated statute. Because of that legal foundation, the CBI requires the general consent of a state government before it can investigate cases within that state's territory. What is that consent? Consent that once granted, a consent that once granted applies to all future cases unless specifically withdrawn by the particular state government. This is precisely the mechanism several states have withdrawn in recent years, like West Bengal, Punjab, Kerala, Tamil Nadu, Jharkhand, among them at various points. Generally, states governed by a party different from the party in power at the center. A pattern that turns a legal procedural question into a live federalism controversy. And the dispute has now reached the Supreme Court in a new form. When West Bengal filed an original suit against the Union under Article 131, arguing the CBI continued registering cases despite withdrawn consent. And in 2024, the court held that suit maintainable, meaning the constitutional question of exactly where the consent boundary lies is now under live adjudication. That single fact upgrades any answer from textbook to current. Now the 2021 PYQ's precise framing matters. What is that? The power of the states to withhold consent to the CBI is not absolute. Why not absolute? Because withdrawal of general consent only affects the CBI's ability to register a fresh case within that state on its own initiative. It does not stop CBI from investigating a case referred directly by a constitutional court. The Supreme Court or a High Court can order a CBI to investigation under its writ jurisdiction, regardless of whether the state has withdrawn consent or not, because that power flows from the Constitution itself, not from the 1946 Act. So a state's veto is real but partial. A state's veto is real but partial. It blocks the CBI's ordinary statutory route, not the judiciary's constitutional route. If Supreme Court or High Court ordered CBI for an inquiry in particular state does not say we are not going to give consent, etc., etc. That is compulsion through constitutional. So then CBI go and investigate, register the case and the investigation. So it blocks the CBI's ordinary statutory route with the consent, general consent, not judiciary's constitutional route. So this is exactly the same tension we studied under central versus state power in federalism. Replied, replayed in the criminal justice space. So national uniformity and anti-corruption capacity on one side, state autonomy over policing on the other. And comes to the criticism part, the caged parrot, the caged parrot. The CBI accused of acting under political direction of whichever party controls the center. Adds an accountability dimension on the top of the federalism one and traces back to Vinith Narayan versus Union of India 1997 case, where the Supreme Court pushed for institutional insulation of the CBI from executive interference, including a fixed 2-year tenure for the director and CVC superintendents over corruption investigations. In Vinith Narayan versus Union of India case, in 1997 fixed 2-year tenure for a director. CVC Superintendents over Corruption Probes, directed by Supreme Court. So carry two reform citations for value addition as far as examination is concerned. The second ARC and successive parliamentary standing committee reports have recommended that the CBI be given its own comprehensive statute replacing the fragile 1946 foundation with a clear charter, functional autonomy, and an independent committee based appointment process for its director. A version of which now exists. The director is selected by a committee of the Prime Minister, the leader of the opposition, and the Chief Justice of India or a nominated judge. Alongside the CBI sits the National Investigation Agency. This is all about CBI. CBI 1946 Delhi Police Establishment Act. Then states beyond Delhi. Then general consent. Then caged parrot. Then constitutional route. And then statutory route. States veto through judiciary constitutional route. And then caged parrot. Then Vinith Narayan and Union of India 1997. Then selection process. Alongside the CBI sits the National Investigation Agency. What is the National Investigation Agency? National Investigation Agency created after the 2008 Mumbai attacks, specifically for terrorism and a defined list of serious offences. Its design deliberately differs from the CBI's. The NIA can take up a scheduled offense and investigate across state lines without needing the state's consent, case by case. A departure Parliament justified on the ground that terrorism by nature ignore state boundaries for terrorism. The 2019 amendment expanded its jurisdiction further to extraterritorial offences and additional categories like human trafficking and cyber terrorism, reopening the same federalism debate in a new arena. How far can union override ordinarily state held police power in the name of national security uniformity? Comes to the answer writing. The 2021 question again in different words here. I am asking. Examine the federal tensions arising from states withdrawing consent to CBI and assess whether the power to withhold consent is truly absolute. Comes to the answer. First and foremost, after reading the question, what you have to do? Answer. Explain the legal basics of CBI's jurisdiction under the 1946 Act. Then the mechanism and effect of withdrawing general consent. Then the constitutional court exception that limits the veto scope, cites Vinith Narayan and the pending Article 131 suit. Briefly contrasts this with NIA's no consent design, then the security rationale behind it, and concludes with reform suggestions like a dedicated CBI statute and a more insulated appointment and oversight mechanism, as the second ARC recommended, that could reduce the trust deficit, driving states to withdraw consent in the first place. So in this way, you have to write an answer. First, explain the first and foremost after reading the question. The question, what you have to do. Question, examine the federal tensions arising from states withdrawing consent to the CBI and assess whether the power to withhold consent is truly absolute. This is the question. Answer structure like this. Explains the legal basis of CBI jurisdiction under the 1946 Act. Then the mechanism and effect of withdrawing general consent. Then the constitutional court exception that limits the veto scope. Cites Vinith Narayan and the pending Article 131 suits. Then briefly contrasts this with NIS no consent design and the security rationale behind it. Then concludes with reform suggestions like a dedicated CBI statute and a more insulated appointment and oversight mechanism as the second ARC recommended that could reduce the trust deficit driving states to withdraw consent in the first place. So this is the way of writing an answer. So let us summarize. The CBI's authority sits on fragile statutory foundation dependent on state cooperation that has become increasingly political. But the NIA was deliberately built to avoid that same fragility for terrorism cases. Both raise the same underlying question this entire chapter keeps returning to. So, how much central power is necessary for effective governance and how much erodes the federal bargain? Then we are moving to next section, that is commissions for vulnerable groups. NCSC, NCST, NCBC, NCW, and NCPCR. This brings us to cluster part 1 mentioned only in passing. NCW and NCPCR appeared in a single sentence inside the general body's overview. That is why we are taking the same commissions for vulnerable groups comprehensively here. The PYQ record 2018, 2022 and the recurring welfare and vulnerable section questions tells us this cluster deserves comparative structured treatment because UPSC's favorite move here is comparison, not description. So start with constitutional versus statutory distinction because this is exactly what the 2022 PYQ tested directly. NCSC, National Commission for Scheduled Castes, then NCST, National Commission for Scheduled Tribes or Scheduled Tribes, are both constitutional bodies under Articles 338 and 338A respectively. So notice something here. UPSC likes to test. These were originally a single combined commission for SCs and STs. The 89th Constitutional Amendment Act 2003 split them into two separate commissions, each empowered to investigate specific complaints, monitor safeguards, and report directly to the president. Report directly to the president. So, what is the thing here? Splitting them was itself a governance decision. Why? Recognizing the scheduled castes and the scheduled tribes face distinct, not identical, forms of disadvantage, and a combined commission risk diluting focus on either. So that is why this happened. So comes to the NCBC. NCBC. What is NCBC? National Commission for Backward Classes is where the 2022 question concentrates its interest. It began life it began life as a purely statutory body, NCBC, then created statutory body created by an act of parliament in 1993 following the Mandal Commission implementation. In 2018, the 102nd the 102nd amendment, constitutional amendment, elevated it to constitutional status under Article 338B, giving its powers similar to NCSC and NCST, National Commission for Backward Classes. Under Article 338B, giving it power similar to NCSC and NCST, the power to examine complaints, advise on inclusion or exclusion from OBC lists, and report to the President. This is a genuinely important UPSC point you have to understand. It shows Parliament using the constitutional amendment process itself to upgrade an institution from statutory to constitutional status, rather than creating something new from scratch. It is proof that the Constitution's rigidity flexibility balance we studied in salient features operates in practice, not just in theory. So that is you have to understand here and carry the sequel, because it completes the history, it completes the story and doubles as a federalism point. The 102nd Amendment's wording led the Supreme Court in the Maratha reservation case, that is Jai Shri Lakshman Rao Patil in 2021, to hold that only the center could identify socially and educationally backward classes, prompting Parliament to pass the 105th Constitutional Amendment 2021, expressly restoring the state's power to maintain their own SEBC list. One institution, two amendments, one Supreme Court judgment, and a live center state question. That chain is a ready-made answer paragraph. Why does constitutional status matter in practice? Beyond prestige, a constitutional body's existence and core powers cannot be diluted by an ordinary act of parliament, only by constitution amendment, which requires a special majority and for certain changes states ratification. A statutory body's powers can be expanded, restricted, or even abolished by a simple parliamentary majority. But so constitutionalization is really about insulating an institution's core mandate from the shifting preference of whichever government happens to hold a majority. So this is the importance of constitutionalization. Comes to NCW, National Commission for Women, remains statutory, created under the National Commission for Women Act 1990. And notice this commission has been tested twice in UPSC mains examination. In the 2017 PYQ asked whether the NCW can strategize and tackle the problems women face in both public and private spheres. And that comes to the 2020 PYQ, UPSC asked directly whether constitutionalizing it would ensure greater gender justice. NCW 1919 Act. 1990 Act statutory. The honest analytical answer UPSC wants is not as simple as directly whether constitutionalizing it would easy ensure greater gender justice. Constitutional status protects an institution's existence and mandate, but does not automatically solve problems of inadequate funding, weak enforcement powers, or limited follow up mechanisms, which are the NCW's actual practical limitations. Status protects independence from statutory to constitutional, but it does not manufacture capacity. Comes, comes to NCPCR, National Commission for Protection of Child Rights, is also statutory body. It is also statutory body NCPCR created under the Commission for Protection of Child Rights Act 2005. And in 2025, a question asked in the UPSC mains examination, child protection in the digital era, meaning online exploitation, cyberbullying, data privacy for minors, and algorithmic content exposure. This is the question. A good example of how even an older institution gets tested through a contemporary governance lens. You have to understand. For value addition here, link it to the DPDP Act. What is the DPDP Act? Data protection. And 2023's specific protection for children's data, verifiable parental consent, prohibition on tracking and targeted advertising directed at children, which gives NCPCR's digital era mandate an actual legislative hook. So a recurring structural weakness across this entire cluster worth remembering for any comparative question, most of these commissions have investigate and recommendatory powers. Similar to a civil court in some respects, like summoning witnesses, requiring evidence, but their recommendations are not binding on the government. That gap between investigative teeth and enforcement power is the single most common criticism UPSC expects you to raise across NHRC, NCW, NCPCR, and even NCSC, NCST, and NCBC, despite their constitutional status. This is the cluster, this is the shared weaknesses. Civil court like powers to summon and take evidence, but recommendations only. These recommendations are not binding on government. Investigative teeth without enforcement power. The single most common criticism across NHRC to NCBC. Comes to the answer writing part. The question like this: discuss the significance of NCBC's transformation from a statutory to a constitutional body, and assesses whether constitutional status alone ensure effective protection of vulnerable groups. This is the question. I will repeat it again. Discuss the significance of NCBC's transformation from a statutory to a constitutional body, and assesses whether constitutional status alone ensures effective protection for vulnerable groups. This is the question. Answer should like this. Traces, first and foremost, traces the 102nd Amendment's background, then explains the practical differences between statutory and constitutional protection, then brings in the Maratha judgment and then 105th Amendment as its live sequel. then compares NCBC's new status with NCSC and NCST's older constitutional standing with NCW or NCPCR's continuing statutory status, and concludes the constitutional status secures independence and permanence must be paid with adequate funding, staffing, and building and binding enforcement mechanisms to translate into real protection. Simply saying, one institution from statutory to constitutional conversion is alone not alone sufficient, is not alone sufficient, because action is important, like staffing, adequate funding, enforcement mechanisms, rather than recommendational work only. Government have to recommend rather than recommendation binding. So rather, simply conversion from statutory to constitutional is alone not sufficient. The action is also need of the hour. The recommendations of these institutions government has to bind, and paired with adequate funding, staffing, these enforcement mechanisms to translate into real protection. So let us summarize. This cluster is not 5 separate topics to memorize in isolation. It is one recurring theme tested comparatively. Tested comparatively. Which vulnerable groups have constitutional protection? Which have only statutory protection? Why the distinction was made or changed? And whether either form of protection actually delivers outcomes on the ground. That is the most important thing. Final thing, that is outcomes on the ground. So after looking these institutions, a quick recap is need of the hour. So before we move ahead, let us anchor this visually, because this exact distinction keeps returning across the whole chapter. That is constitutional bodies so far. Comes to the CAG, constitutional bodies, CAG, under Article 148, that is Comptroller and Auditor General. Then NCSC, Article 338, that is National Commission for Scheduled Castes or Scheduled Castes. National NCST, Article 338A, NCBC, Article 338B, with 102nd Amendment. This is the existence and core powers changeable only by constitutional amendment. Comes to the statutory body. So far, attorney general, attorney general supporting law officer, apparatus aside, remember NCW 1990 Act, then comes to NCPCR 2005 Act, and coming up shortly NHRC 1993 Act, and the Information Commissions RTI Act 2005, and Lokpal 2013 Act, CBI, DSPE, Delhi Special Police Establishment Act 1946. One line rule to carry forward, that is constitutional status protects an institution's existence and core mandate from an ordinary parliamentary majority. Statutory status does not. Independence is about protection from being diluted, not a guarantee of strong powers appear. Simply saying, constitutional status protects existence and core mandate from an ordinary majority. It is protection from dilution, not a guarantee of strong powers on paper. That is the main thing you have to understand. Our next institution we are going to discuss is the NHRC, that is National Human Rights Commission, a watchdog without teeth. It appeared in the PYQ record in 2021 and 2014, both times with the same underlying challenge embedded in the question. What is UPSC asked in 2021 and 2014? We are going to take. That is, this institution has real limitations, and UPSC wants you to name them honestly, not defend the institution uncritically. So this is the thing what we have to do. So we are going to learn, that is NHRC is a statutory body. Simple. NHRC is a statutory body which is created under the Protection of Human Rights Act 1993. 1993. In response to India's international human rights commitments and growing domestic concern about custodial deaths, encounters, and rights violations by state agencies themselves. Notice the irony this creates. An institution meant partly to check abuse by the police and security forces, staffed largely by retired judges and officials who come from within that same administrative ecosystem. That is the irony. So, from 2019 amendment to the act, you have to know that, because it is the most recent structural change and slots naturally into any answer. The Protection of Human Rights Amendment Act 2019 reduced the tenure of the chairperson and members from 5 years to 3 years. Widened eligibility for the chairperson from only a former Chief Justice of India to any former Supreme Court judge. Increased the number of members and made the chairpersons of NCW, NCPCR, NCBC, and Chief Commissioner for persons with disabilities deemed to be members. Critics read the shortened tenure and widened eligibility pool as increasing, not reducing, executive leverage over appointments. The same independence logic recurring throughout these chapters. Let's see. We are going to test what the functions NHRC do. Its functions: inquiring into complaints of human rights violations, either on its own initiative or on petition, and reviewing safeguards under any law for the protection of human rights, and visiting jails and detention facilities to study living conditions, and promoting human rights literacy and research. These are the functions. This is a fairly wide investigative mandate on paper. Comes to the limitation part. What are the core limitations of NHRC, which both PYQs push you toward? The NHRC findings are only recommendatory. Only recommendatory. It cannot punish a violator directly, cannot enforce compensation on its own authority. And this is the detail UPSC specifically likes. It cannot directly investigate a human rights violation by the armed forces. It can only seek a report from the central government and make recommendations based on that report. Given that a significant share of custodial and encounter related complaints India receives involve security forces operating in conflict affected regions. This exclusion is not a minor technicality. It removes the Commission's teeth in precisely the category of cases where independent scrutiny may matter most. Findings are only recommendatory, cannot punish or enforce compensation. Comes to the armed forces part, cannot investigate directly by NHRC, may only seek a report from the central government. This is not a minor technical issue. This is exclusion is not a minor technicality. It removes the commission's teeth in precisely the category of cases where independent scrutiny may matter most. And 1 year limitation too. The NHRC cannot inquire into a matter more than 1 year after the alleged violation. A small class with a large practical consequence in conflict affected and custodial contexts where complaints of surface late. 1 year bar, 1 year bar on inquiries, heavy cost where complaints surface late in the conflict and custodial context. 1 year limitation, the NHRC cannot inquire into a matter more than 1 year after the alleged violation. The NHRC cannot inquire into a matter more than 1 year after the alleged violation. A small class, it looks like a small class with a large practical consequences in conflict affected and a custodial context where complaints surface late. A contemporary credibility point that must now anchor by NHRC answer. Because it is a historic first. After deferring the NHRC's re-accreditation in 2016, 2023, and again in 2024, the Global Alliance of National Human Rights Institutions downgraded the NHRC from A to B status in 2025. A recommendation made at the subcommittee on accreditation session in early 2025, and after the NHRC's challenge failed, upheld by GANHRI Bureau in December 2025. The stated grounds read like a checklist of this chapter's scheme: lack of independence from government interference, and opaque and insufficiently plural appointments processes, the continued secondment of police officers as investigative staff, an inherent conflict when the complaints are against police, and failure to address systemic violations rather than only individual cases. So NHRC, the 2025 GANHRI downgrade. A to B, downgraded in 2025 after deferrals in 2016, 2023, and 2024. NHRC's challenge failed, upheld by the GNHRI Bureau in December 2025. What is the benchmark? The UN Paris Principles 1993, independence, pluralism, and adequate resources. The practical consequence is real, not symbolic. B status strips the NHRC of independent participation rights at the UN Human Rights Council and of voting rights with GANHRI. International accreditation has in effect delivered the verdict domestic critics had long argued that the watchdog's structure compromised its bite. Comes to the 2014 PYQ's framing is the key insight to remember. NHRC is most effective when its work is supported by other mechanisms. A responsive judiciary willing to act on its recommendations, media attention that creates public pressure, and a parliament and executive willing to accept its findings rather than ignore them. In other words, the NHRC's real power is moral and reputational, not coercive. Why? Because it depends on other institutions choosing to act on what it finds. So that is the main thing here. So lack of independence from government interferences, opaque insufficiently, plural appointment process, police officers seconded as investigators, individual case only focus. The real consequences like losses independent participation rights at the UN Human Rights Council, losses voting rights within GANHRI. The international accreditation delivered the verdict, domestic critics long argued. From A to B. Comes to the answer remedies, binding response timelines, narrow the armed force carve out, independent investigative cadre, resource state commissions. Comes to the answer writing part, NHRC has contributed immensely to rights protection. It has failed to assert itself against the powerful. Analyze its structural and practical limitations and suggest remedies. What is the answer? First and foremost, answer explains the statutory basis and functions and identifies the recommendatory only nature of its findings as the central structural weakness, then discuss the armed forces exclusion and 1 year bar specifically, and then cites 2019 2019 amendment and the 2025 GANHRI downgraded from A to B status as clinching evidence, evaluates state human rights commissions parallel and often weaker capacity and suggests reforms, binding timelines for government response to NHRC recommendation, removing or narrowing the armed forces carve out, an independent investigative cadre instead of seconded police officers, better resourcing state commissions. After discussing NHRC so far, what you have to understand, the examiner is really testing whether you can see past the institution's wide mandate to its narrow bite. The NHRC can see and speak, but it cannot enforce because it is recommendatory only rather than enforcing. It is depending on secondary police force and comes to armed forces. It may act on central government report and 1 year bar. These are the limitations, core limitations. Whether it protects rights in practice depends almost entirely on whether other institutions are willing to listen. So this is the thing we have to understand regarding NHRC. Then we are moving to information commissions and the right to information. Let us now turn the transparency. What is the transparency? In the part 1, we mentioned CIC alongside NHRC and Lokpal in one sentence. For excessive, for extensive comprehensive coverage, we have taken these information commissions and right to information here. The 2020 PYQ makes clear this needs standalone treatment. In 2020, what UPSC asked, it asked directly about specific amendments impact on information commission independence, which requires knowing the institutional design, not just the name. What is the design? RTI and information commissions. Why? Why did India need a right to information act at all? Go back to the executive accountability in part 1. Parliament, the judiciary, the CAG all hold the executive accountable through institutional channel. Right to information, enacted in 2005, created something different, a direct channel for the ordinary citizen to demand information from public authorities, converting the abstract idea of transparent governance into an enforceable individual right. Transparency made an enforceable individual right from RTI 2005. A direct citizen channel. Transparency made an enforceable individual right. It is, in that sense, a directive principle style value, transparency, accountability given teeth through ordinary legislation. Much like the Representation of People's Act gave teeth to universal adult franchise. The second ARC, Administrative Reform Commission's very first report, Right to Information, master key to good governance, is the citation to attach here. It called RTI the master key precisely because transparency unlocks every other accountability mechanism, and quoting that title is one line value additions examiner recognize instantly. So that is the RTI's importance. RTI importance we have to know. The Central Information Commission and State Information Commissions are statutory bodies. Are statutory bodies created under the RTI Act, headed by a chief information commissioner, empowered to hear appeals when a citizen's information request is denied or ignored. And importantly, with powers similar to a civil court, like summoning records, imposing penalties on erring public information officers who withhold information without valid exemption. Comes to the PYQ, 2020's PYQ, specific concern. The RTI Amendment Act 2019 changed how the Chief Information Commissioner and Information Commissioners are appointed, their tenure, and their salary, moving these from being fixed by the Act itself, comparable to an election commissioner status, to being determined by the central government through rules. Why does this matter? Because an official whose tenure and salary can be altered by executive rule making rather than fixed in statute is structurally more vulnerable to executive influence. That's it. Simple thing. Precisely the same independence logic we studied for CAG, the judiciary, and the Chief Election Commission, etc. The concerns raised is not hypothetical politics. It is the same structural principle bodies that hold the executive accountability, and executive accountable need protection from the executive's discretion over their own terms of services. That is the simple thing you have to understand. Independence. At the second quieter crisis here is because it strengthens any answer. Chronic vacancies. Chronic vacancies in Anjali Bharadwaj versus Union of India 2019 case, the Supreme Court directed timely transparent filing, transparent filling of information commission posts at several state commissions have at times has been headless or entirely defunct, and pendency of appeals run into years in some states. An accountability body that exists on paper but cannot hear appeals is functionally equivalent to nobody at all. That is the practical companion to the 2019 amendment structural concern. Comes to the RTI Amendment Act 2019, tenure and salary moved from statute to central government rules, and officially whose terms rest and executive rulemaking is structurally more vulnerable to executive influence. Same independence principles as CAG, judiciary, and election commissions. So bodies that hold the executive accountable need protection from the executive's discretion over their own terms of service. So RTI also has genuine non-political limitations worth knowing. What are they? What are they? Exemptions under Section 8 for information affecting national security, strategic economic interests, cabinet papers during deliberation, and personal information without public interest justification, a legitimate and necessary balance. But one government agencies sometimes invoke more broadly than the exemptions spirit intends, which is where litigation and information commission rulings on the scope of exemptions become important. In section 8 exemptions, we are talking about national security, strategic economic interest, cabinet papers, personal information, a legitimate balance, a legitimate balance, but often invoked more broadly than its spirit intends. So one more recent layer for a truly current answer, we have to write the DPDP Act 20 Digital Data Protection Act 2023 amend section 818 clause 1J of the RTI Act, broadening personal information exemption by removing the public interest override language. Transparency activists argue this narrow RTI's reach precisely where it exposed wrongdoing by identifiable officials. The DPDP Act 2023 amended Section 8, Clause 1, Subclass J, that is, public interest override. Public interest override removed from the personal information exemption. Activists say it narrows RTI exactly where it exposed wrongdoing by identifiable officials. Comes to the 2020 question, recent amendments to the RTI Act will have a profound impact on the autonomy and independence of the Information Commission. Discuss. Answer should be like this. First and foremost, explain. Explain RTI's constitutional and democratic rationale with the second ARC citation. Then describes the pre-amendment statutory protections for commissioners' tenure and salary. Describe the pre-amendment statutory protections for commissioners' tenure and salary. Then explains precisely what 2019 amendment changed and why critics see it is reducing insulation from executive control. Adds the vacancy problem, and Anjali Bharadwaj case presents the government's counter argument that flexibility allows better alignment with the changing administrative needs, and concludes with a balanced assessment of whether the change genuinely threatens independence or is a manageable administrative adjustment. So this is the way of writing an answer from constitutional RTI, then roles from constitutional from answers RTI's constitutional and democratic rationale with the second ARC citation, good governance. Then describes the pre-amendment statutory protections for commissioners, tenure and salary. Then explains precisely what 2019 amendment changed and why critics see it as reducing insulation from executive control. Then adds the vacancy problem and Anjali Bharadwaj versus Union of India 2019 case presents the government's counter argument that flexibility allows better alignment with changing administrative needs, and then concludes with a balanced assessment of whether the change genuinely threatens independence or is a manageable administrative adjustment. This is the way you have to write an answer in the mains examination. So let us summarize. RTI turned transparency from a governance ideal into an enforceable citizen right. The information commissions are the institutional machinery that makes the rights meaningful. And exactly like every other watchdog we have studied so far, their independence depends on how insulated their own terms of appointment and removal are from the very executive they are meant to hold accountable. So, for the independence of any watchdog, the removal, appointment, etc., is one of the most important thing. The RTI, the quieter crisis, I am repeating again, chronic vacancies, Section 8 exemptions, DPDP Act 2023 layer, and balanced close like this. Does the 2019 change genuinely threaten independence or is it a manageable administrative adjustment? Have to present both. This is the most important thing for as far as RTI and Information Commission is concerned. Then we are moving to administrative tribunals, and the competitive commission. Two threads converge into the next scene, that is administrative tribunals tested in 2025, 2019, 2018, making it one of the more consistently asked quasi-judicial topics. And the Competition Commission of India tested in 2023. Can we recall the constitutional logic from part 1's body scene? What is that? Not every dispute needs a regular court because some disputes require specialized technical expertise a generalist judge may not possess. In that scene, administrative tribunals enter the scene. Administrative tribunals created under Article 323A for service matters and Article 323B for other specified matters like taxation, land reforms, and elections, both inserted by the 42nd Amendment in 1976. Exist precisely for this reason. Comes to the Central Administrative Tribunal. For instance, it was set up under the Administrative Tribunals Act 1985 to hear disputes involving central government employees' service conditions like recruitment and disciplinary matters, taking this specialized category of litigation away from already overburdened high courts. When it comes to the 2019 PYQs, framing is worth sitting here with this. In this question they asked, UPSC asked, is that CAT exercising its power as an independent judicial authority beyond its original design as a grievance redressal mechanism? This is the question. This is really asking whether tribunals have evolved from administrative bodies into quasi courts. And the honest answer is yes. Substantially, through judicial interpretation over the decades, which raises the 2018 PYQ's exact concern. Do tribunals curtail the jurisdiction of ordinary courts? Do tribunals curtail the jurisdiction of ordinary courts? Name the case here, because it is the anchor citation for this entire debate. So that is why we are going to cite the case here. For example, the question you have to write an answer, you have to cite the case here. That is L. Chandrakumar versus Union of India 1997, where a 7-judge bench held that tribunals cannot completely oust High Court judicial review under Articles 2026 and 2027, like Article Judicial Review under Articles 226 and 227, because judicial review by constitutional courts itself part of the basic structure as we established earlier. Look at the judgment in the L. Chandrakumar versus Union of India 1997, where a 7th-judge bench held that tribunals cannot completely oust High Court's judicial review under Articles 226 and 227. Why? Because judicial review by constitutional courts is itself part of the basic structure as we established earlier. So tribunal decisions are therefore subject to scrutiny by a High Court division bench. So tribunals supplement the court system as courts first instances in their domain. They cannot constitutionally replace it. Tribunals are Tribunals cannot constitutionally replace it. Tribunals decisions are therefore subject to scrutiny by a High Court division bench for judicial review. Tribunals are supplement the court system as courts of first instances in their domain, but they cannot constitutionally replace it. Then comes to the 2025 PYQ, adds a very current layer, that is the 2021 Tribunal Reforms Act, which abolished several existing appellate tribunals, most prominently the Film Certification Appellate Tribunal and the Intellectual Property Appellate Board. In 2021 Tribunals Reforms Act, which abolished several existing appellate tribunals and transferred their functions back to existing courts or other tribunals. Partly in response, why why this happened? Partly in response to litigation over tribunal members. Tribunal members what? Litigation over tribunal members' qualifications, tenure, and independence from the executive that appoints them. The reforms rationale was rationalization and reduced litigation cost. The criticism is that abolishing specialized tribunals may simply shift the burden back onto already overloaded high courts. That is undermining the very efficiency tribunals were meant to provide. And here is where the story gets a fresh, important twist. What is that important twist? One that happened after that reform was already being taught as settled fact in most 2025 material. On November 19, 2025, the Supreme Court struck down the core provisions of the very on November 19, 2025, the Supreme Court struck down the core provisions of the very same 2021 Tribunals Reforms Act, specifically the sections governing tenure and appointment of tribunal members. The bench's reasoning is worth sitting with carefully. What is that? Because it is a rare and direct confrontation between Parliament and the court. The judges held that Parliament had already lost this exact argument once before in the Madras Bar Association line of judgments, which mandated a 5-year tenure for tribunal members, a minimum of 10 years bar experience for judicial appointees, and protections against executive dominance in the selection process. The 2021 Act, the court found, simply reintroduced the same struck down provisions with the what the Chief Justice called minor tweaking. A 4-year tenure, a 50 a 50-year minimum age, and the court labeled this as legislative overruling. Holding is unsustainable because it violated separation of powers and judicial independence without actually curing the constitutional defect the court had originally identified. This matters enormously for how you should now answer the 2025 PYQ. It is no longer enough to describe the 2021 reform as a settled rationalization exercise. The more current and more analytically rich answer is that the reform's own appointment architecture has now been invalidated by the same judiciary whose caseload it was meant to relieve. The court has directed the center to establish a national tribunals commission with 4 months an independent permanent body meant to oversee appointments, tenure, administration across the entire tribunal system. Precisely the kind of structural insulation from executive control that this whole chapter keeps circling back to. Track this actively between now and the exam before August 2021, August 21, 2026. Whether the National Tribunals Commission is actually constituted and in what form is exactly the kind of follow-up development UPSC falls into the next year's question, maybe in 2026. Now the competition commissions we are coming to. So you have to be very careful regarding administrative tribunals because court struck down the case in 19 November 2025 and court ordered National Tribunals Commission formation and appointments and tenure etc. from particular National Tribunals Commission, that is a permanent body meant to oversee appointments, tenure and administration process through the across the entire tribunal system. So you have to be very careful with this. Now the now to come to the Competition Commission of India. Next section, that is Competition Commission of India. The 2023 PYQs subject a regulatory cum quasi judicial body created under the Competition Act 2002, replacing the older MRTP Commission on the recommendation of the Raghavan Committee, tasked with preventing practices having an adverse effect on competition, promoting fair competition, and protecting consumer interests. Comes to the specific PYQ concern here, abuse of dominant position by multinational corporations points to CCI's growing relevance in the digital economy. The CCI Competition Commission of India's Orders against Google in the Android and Play Store matters. Imposing penalties running into thousands of crores for self-preferencing and restrictive app store practices. Are the ready-made examples practices like self-preferencing, predatory pricing, or restrictive data practicing are precisely where abuse of dominance. Abuse of dominance doctrine stresses tested by platform ecosystems and network effects. Restrictive data practices are precisely where abuse of dominance doctrine is being tested in genuinely new ways. Since traditional competition law was designed for physical markets, not platform ecosystems with network effects. Two current layers complete the picture. The Competition Amendment Act 2023 introduced deal value thresholds for merger scrutiny, designed to catch big tech acquisitions of small but data rich startups that escaped the old asset and turnover tests, along with settlements and commitment mechanisms. And the purpose digital competition bill recommending ex ante regulation of systematically significant digital enterprises signals the next frontier of this debate and filed the CCI within a broader PYQ family. That is why UPSC keeps returning to under this topic. The 2015 question on whether regulatory institutions can remain independent and autonomous comes to the 2014 Rail Tariff Authority question, comes to the 2013 CBI IRDA merger question, all of which are really the same independence and design question this chapter keeps asking, applied to regulators instead of watchdogs. So this is the current layer. This is the competition. This is the Competition Amendment Act 2023. Deal value thresholds catches, big tech buys, data rich startups, settlements and commitments. Proposed digital competition bill, ex ante regulation of systematic significant digital enterprises. So what is the Competition Commission of India? I'm repeating again this entire chapter for convenience, for easy understanding, because it's growing. So now comes to the CCI. CCI, design and digital dominance. What is the digital and the design dominance? Competition. It is Competition Act 2002, a regulatory cum quasi judicial body, Competition Commission of India, created under the Competition Act 2002, replacing the older MRTP Commission on the recommendations of the Raghavan Committee. Tasked for Raghavan Committee for tasked what? With preventing practices having an adverse effect on competition, promoting fair competition, and protecting consumer interests. For that, Raghavan Committee appointed. The specific PYQ concern is what here? Abuse of dominant position, abuse of dominance, abuse of dominance doctrine, stress tested by platform ecosystems and network effects. What is the abuse of dominance doctrine? Abuse of domination position by multinational corporations. You have to be very careful with abuse of dominance doctrine. You have to go through it once. Abuse of dominant position by multinational corporations points to CCI's growing relevance in the digital economy. The CCI's orders against Google in the Android and Play Store matters, imposing penalties running into thousands of crores for, for what? self-preferencing, and restrictive app store practices. Self-preferencing and restrictive app store practices are the ready-made examples. Practices like self-preferencing, predatory pricing, or restrictive data practices are precisely where abuse of dominance doctrine is being tested in genuinely new ways. So since the traditional competition law was designed for physical markets, but now digital economy, era of digital economy, not platform ecosystems with network effects, the older law. So two current layers complete the picture with the amendment of Competition Act 2023 that is introduced deal value thresholds, deal value thresholds for merger scrutiny. Designed what, why, for designed, for this design what, to catch big tech acquisitions of small but data rich startups that escaped the old asset and turnover tests, along with settlement and commitment mechanisms. Introduced what? Competition Amendment Act 2023 introduced deal value thresholds, deal value thresholds for merger scrutiny, for merger scrutiny, designed to catch big tech acquisitions, big tech acquisitions of small but data rich startups, small but data rich startups that escaped the old asset and turnover tests, along with the settlements and commitment mechanisms. And the proposed digital competition bill recommending ex ante regulation of systematically significant digital enterprises. That is signals the next frontier of this debate. So you have to be very careful with digital competition bill also and file the. So CCI, Competition Commission of India, is PYQ family. We are taking within a broader PYQ family. UPSC keeps returning to under this topic from 2015, 2014, 2013. So the 2015 question, whether regulatory institutions can remain independent and autonomous. That is the question in 2015. The same question older class. 2015 question what? Regulators independence. Then 2014 Royal Tariff Authority. Then 2013 SEBI IRDA merger, Security Exchange Board of India and IRDA Insurance Regulatory Development Authority merger question, all of which are really the same independence and design question this chapter keeps asking, applied to regulators instead of watchdogs. So that is why Competition Commission of India, this PYQ family, you have to be very focused, very conscious for next 2026 or 2026, 2027. The digital competition bill, you have to be very focused. One more block before we close this scene, that is because the 2024 PYQ asked it directly and belongs squarely under specialized justice, that is Lok Adalats versus arbitration. What is Lok Adalats and what is arbitration? Lok Adalats were versus arbitration tribunals, explain and distinguish unto they entertain civil as well as criminal cases. These are two main alternative dispute resolution routes and they differ at every structural level. Lok Adalats, come to Lok Adalats. They are both ADRs, alternative dispute resolution systems. These are two main alternative dispute resolution routes and they're different at every structural level. You have to understand, you have to remember. Lok Adalats are statutory, created under the Legal Services Authorities Act 1987 and organized by the Legal Services Authorities NALSA at the national level, whose role in delivering free legal aid to eligible categories like women, children, SCs and STs, industrial workmen, person with disabilities, persons in custody, and those below the income ceiling was itself the 2023 PYQ. So a Lok Adalat works by conciliation and compromise, not adversarial adjudication. No court fee and fees already paid are refunded if a pending case settles. And it's awarded is deemed a decree of a civil court, final and binding, with no appeal lying against it. A dissatisfied party's only route is fresh litigation. On jurisdiction, the 2024 question specific sting, that is local adalats can take up civil cases and those criminal cases that are compoundable under law, but non-compoundable offenses. At the 2002 amendments, permanent lok adalats for public utility services, which can decide a dispute on merits if conciliation fails. A genuine adjudicatory power, the ordinary lok adalat lacks. So lok adalats 2002 amendments, permanent lok adalats for public utility services, which can decide a dispute on merits if conciliation fails. A genuine adjudicatory power, the ordinary lok adalat lacks. That is the lacking power, that is the limitation. Comes to the arbitration. Arbitration is the opposite in origin and nature. Arbitration. Contractual, not statutory in trigger, governed by the Arbitration and Conciliation Act 1996, arising only from an agreement between parties, decided by an arbitrator. The parties themselves choose, producing a binding award enforceable as a decree with only narrow judicial interference on limited grounds and confined to civil and commercial disputes. Criminal matters are entirely outside arbitration, only civil and commercial disputes, because criminal law is a claim of the state, not a private bargain. Here, one line distinction to carry, that is, Lok Adalat is a state provided conciliation open to the poorest litigant at zero cost. On the other hand, arbitration is party chosen private adjudicator. Arbitration is party chosen private adjudication, typically for commercial disputes. Both decongest courts, but from opposite ends of the litigation spectrum. Comes to the answer writing part, the question like this: comment on the need for administrative tribunals compared to the court system, and assess the impact of the 2021 tribunal reforms. Comment on the need for administrative tribunals compared to the court system, and assess the impact of the 2021 tribunal reforms. The answer should be like this: explain the constitutional basis and rationale for specialized adjudication. Cites L. Chandrakumar for the tension between tribunal efficiency and preserving High Court judicial review as a basic structure guarantee case. Evaluates the specific tribunals abolished in 2021 and the stated versus actual effect of the reform, and should now also reference the Supreme Court's November 2025 verdict striking down the Act's tenure and appointment provisions as legislative overruling of the Madras Bar Association presidents, treating the still awaited National Tribunals Commission as the next real test of whether tribunal independence can be structurally guaranteed rather than repeatedly litigated. So let us summarize here. Tribunals and regulators like CCI exist because modern governance is too technical for generalist adjudication alone. But their independence and their relationship with the constitutional court above them remains a permanent site of tension that UPSC keeps returning to under new names and new reforms. And as of late 2025, the tension is no longer theoretical. Why? The court has now told Parliament in direct terms that it cannot re-legislate its way around settled constitutional principle. So comes to the again I am repeating, Lok Adalats versus arbitration. Comes to the Lok Adalats, it is a statutory under Legal Services Authorities Act 1987. These are organized via NALSA, comes to the free legal aid for women, children, SC, STs, and industrial workmen, disabled persons, in custody persons, low income persons. And this is the conciliation and compromise compromising our system. No court fee here. If refunded if your pending case settles. In this award, civil court decree like final, this is final, no appeal. You have to appeal with a fresh litigation. No need of appeal here. You have to file fresh litigation. Comes to the arbitration. What is arbitration? This is civil cases and compoundable criminal only. Comes to the arbitration, this is contractual trigger. Arbitration and Conciliation Act 1996, this is erased only from party agreement. Arbitrator chosen by the parties themselves. Binding award enforceable as decree. Only narrow judicial interference here. Here civil and commercial only. No criminal matter. Criminal matter excluded. Criminal law is state's claim, not a private bargain. You have to remember that thing. Here one line, that is state conciliation at zero cost for the poorest litigant in Lok Adalats versus party chosen private adjudication for commerce in arbitration. Both decongest courts from opposite ends. This is the regarding Lok Adalats, arbitration, CCI, etc.